The US Supreme Court hears a challenge to a wiretapping program that gives the government unprecedented power to intercept communications. How far have civil liberties been eroded under President Obama? You're watching Inside Story Americas from Washington. Hello, I'm Shihab Ratansi. It's a program which has seen thousands, some say millions, of US citizens secretly monitored in what the government argues is the interest of national security. And on Monday, the US Supreme Court is hearing a challenge to the government's controversial wiretapping program. It's been brought by a group of attorneys, journalists, and human rights organizations who say innocent citizens are being monitored merely because they're communicating with someone overseas. The Obama administration is hoping it will be thrown out on a legal technicality and not on the basis of its constitutionality. Following the 9/11 attacks, then US President George W. Bush secretly expanded the Foreign Intelligence Surveillance Act to allow the government to eavesdrop on individuals without obtaining a warrant. It became law in 2008 after getting the approval of the US Congress. According to the American Civil Liberties Union, the program has expanded under Barack Obama. His administration argues the surveillance powers help prevent further attacks on US citizens. Despite promising his presidency would move away from the policies of his predecessor, many campaigners say the opposite has happened, pointing to the expansion of the Patriot Act, drone strikes, and increased powers of detention as evidence of an erosion of civil liberties under Barack Obama.
I voted, along with other members of this Congress, right after 9/11 for the United States to defend itself. But it's equally important that we not lose our freedoms and our constitutional protections while we're engaged in that defense. And we take an oath not only to defend the Constitution, but we have to keep in mind that that oath and that Constitution is really part of America's first line of defense.
Rocky Anderson is the US presidential candidate for the Justice Party. I spoke to him earlier from Salt Lake City in Utah. I asked him how he rated President Obama's record on civil liberties.
I would rank him as an F. We are at the worst state in our nation's history in terms of civil liberties. And I know a lot of people had so much hope that things would be different after the Bush administration, but the abuses under the Bush administration, by and large, have continued, and they've been horribly exacerbated during this administration, and it's been a bipartisan effort. The Republicans and the Democrats have done this to us, but the president's fallen right in line.
Well, what are you specifically concerned about?
Well, we had the Foreign Intelligence Surveillance Act that was passed by Congress after the disclosures by the Church Committee of the horrendous abuses by the intelligence community during the Cold War. And they said, never again will we allow these kinds of warrantless wiretapping by our intelligence agencies of American citizens. It's contrary to our Constitution. It's contrary to our most fundamental values. Well, George Bush lied to this nation, saying that they were getting warrants in every instance, and his administration, along with the NSA, violated that statute. It's a federal felony. Every time they did it thousands of times. We have no idea how extensive those violations were. So instead of dealing with those violations, Congress, and this happened when President Obama was in the United States Senate, passed amendments that allowed the National Security Agency to engage in wholesale, dragnet wiretapping of communications by U.S. citizens with people outside our borders. They're mining over 1 billion communications a day, and they're building, actually miles from where I sit right now, 1 million square foot facility to store these communications. We have basically no privacy rights, and what's happening now at the United States Supreme Court with people challenging this wholesale spying program, the Supreme Court is considering whether those seeking to challenge the unconstitutionality of that act they're considering whether they have standing to sue. Well, when people sued challenging the illegal conduct by the Bush administration, they weren't able to pursue those cases because they weren't able to establish that their communications were subject to surveillance. And the reason they weren't is because the administration invoked the state secrets doctrine, claiming that to disclose that information would mean the disclosure of important state secrets. So it's the circular process now where there's illegal conduct by the executive branch, and the courts are being knocked out completely as a check on that illegal conduct. So we don't have really a system of checks and balances anymore.
Proponents would say that the fact that we're getting so many leaks from the Obama administration about how draconian some of his national security policies are is because they think it's an election winner. This is what the people want. If the people are unhappy, then they can vote for a different Congress.
So we're seeing our republic in greater danger than probably at any time in our nation's history. And because it's a Democratic president, it seems that the Democratic Party and so many Democrats are allowing partisanship to overrule any kind of principled approach to sustaining our republic.
So what is Barack Obama's record on civil liberties? With me to discuss this in the studio is author and national security analyst David Isby, and from Dallas, Texas, Chip Pitts, a law professor at Stanford University and an international human rights activist. Professor Pitts, first of all then, perhaps you can just talk us through the FISA amendment, the Foreign Intelligence Surveillance Act of 2008. What exactly are we talking about here?
Well, essentially, Shihab, the Foreign Intelligence Surveillance Act was actually instituted to protect American rights in the 70s after abuses were disclosed. But in 2008, Congress passed a law essentially ratifying the Bush program of warrantless surveillance. And that's at issue in the Supreme Court's case being argued today, Clapper versus Amnesty International et al.
But what does that actually mean? Can anyone basically be surveyed, or is it simply making overseas phone calls? Just explain it to us a bit in a bit more detail.
You bet. The proponents of the law say that it only allows targeting of foreigners, and then it would thus be in keeping with the Foreign Intelligence Surveillance Act's division between authorized surveillance of foreigners, especially spies and terrorists, and then criminals domestically, with higher standards, the Fourth Amendment in particular, applying to the latter, American citizens, and not the former. The problem is that both Congress people and administration officials are either misled or being misleading, because they're saying that the law only allows targeting the communications of foreigners. And it allows actually targeting a foreign group, be it Al-Qaeda or even Amnesty International, which is why Amnesty is a plaintiff in this lawsuit, because once this foreign group is targeted, the collection of calls can include calls of U.S. persons. And given current technology, it's often very difficult, in fact impossible, to distinguish whether calls originate domestically or internationally, whether they, with the crossing of borders, whether they're purely domestic or not. The reality in a globalized world is that communications are similarly global. And so American citizens' communications, be it email, phone calls, Skype, instant messages, surfing URLs on the web, all of these are now vulnerable to mass collection as never before in U.S. history.
David Isby, I mean, that's the charge then. This is massive warrantless surveillance, dragnet surveillance, basically, that actually is basically, certainly to the is in opposition to the constitutional protections we're supposed to have in this country.
Well, these fears certainly have been raised from both the left and the right of the American political spectrum, and have been throughout this current administration. But much as it grieves me to say something good about this administration a week before the election, they've normally avoided the horrible results both left and right critics have set out for it, and pursued a policy not much different from its predecessor.
How do we know?
And again, how much we know, we've had open debate in Congress, and more to the point, we've also had the press reporting in the New York Times and elsewhere when the government's disclosure has lagged. So you can never know everything, but I think the question is, we have pretty good idea, better idea than anyone else in the world what's out there, unless one wishes to go into paranoid fantasy land.
Professor Pitts, are we in danger of entering paranoid fantasy land? Are you satisfied with the oversight? Do we know who's being surveyed? What's happening to this information after it's been collected and so forth?
Hardly. I mean, as Woody Allen once said, or someone said, just because you're paranoid doesn't mean they're not out to get you. And in fact, paranoia is quite reasonable here, given the secrecy that accompanies this law. There are no public reporting requirements. The law is in total secrecy. And in fact, due to some leaks by government whistleblowers and so forth, we know that the law has been abused. The Foreign Intelligence Surveillance Court, the secret court that supposedly oversees these communications, has now been disabused of even the limited powers it had. And it has notoriously found, according to the government's own Director of National Intelligence and NSA officials, that the minimization requirements protecting Americans' data from retention and use in unauthorized circumstances has been routinely violated now. We know that this is the case. So we know the case is that the law has been violated according to reporting by the New York Times, other media outlets, and government officials' own admissions. And we also know that the benefits from the security are nowhere near as claimed. I mean, people are saying that this is necessary to protect against terrorism, but in reality, the 9/11 Commission, in saying that we failed to connect the dots, actually warned against the overflow of information that makes it more difficult to connect dots. And so I would argue that these provisions are enacted in a climate of fear without the adequate public debate that my friend David says has happened. We haven't had adequate public debate if the climate is secrecy, there's no public reporting, and the information being given the American public and the world is utterly misleading. And that's the problem with this law. This law is not even challenging the merits of the program. It's challenging the ability of plaintiffs to even have standing to challenge the law. And the catch-22 is that they are being spied on in secret, and therefore they don't have the evidence to prove that the harm exists. And that's the real difficulty in this particular case that's being argued before the Supreme Court today.
Right, David Isby, I mean, that's interesting too, isn't it? So the government argues that you can only challenge this law if you have been monitored yourself. Then it also argues that it's under it has no responsibility to tell the plaintiffs whether they have been monitored. So therefore, of course, they can never, therefore, challenge the law. I mean, it's...
You also get this, I mean, we had this with the Patriot Act revision, and we've addressed some of these problems where, for example, Attorney General Holder in his letters to Senator Leahy, but I am reluctant to go along with the professor's advocacy for paranoia. We've got an internet for that. Nor would his belief that it doesn't work. If he does, he is certainly the wisest man in all America, because even the professionals don't know it doesn't work or don't. Even the professionals...
But shouldn't we be erring on the side of constitutionality and caution when it comes to surveillance and anything warrantless, for example? We should probably be erring on the side of caution in the absence of any further information.
Well, I mean, you don't have a real precedent for that. Certainly, it is something which is approached with great caution. Yes, any law that is passed, the government can and will get it wrong, but it's a very real technology, and the people who are arguing in the other stance will look into the national security powers, and the fact that this has been voted on by Congress not once but twice from the renewal, and you've also been supported by 2 administrations of ideologically highly diverse stripes.
Professor, I mean, you were talking about the enormous amount of information that comes from this sort of data mining. And now last week, the Washington Post had some pretty extraordinary articles about the amount of information being collected by the National Counterterrorism Center, not the National Security Agency now, but the expansion of the National Counterterrorism Center, huge data mining, data collection from any government database we now know. Any of our records, legal, health records, education records, travel records can be mined by the NCTC and then shared to any foreign government, apparently. President Obama as well, he lowered the restrictions on how long that information can be kept by the National Counterterrorism Center as well. Is that correct?
There are provisions that vary by law. There are over 200 data mining programs, Shihab, And, you know, the problem is with all of these is that they are directly against a very important precedent, the precedent that caused the Fourth Amendment to be generated in the first place, the precedent of general warrants, so-called general warrants, that did not specify the person or place, the thing to be searched or seized. That was what the colonists were reacting against at the time of the Declaration of Independence, King George's use of that power. And that was what the Fourth Amendment was enshrined specifically to prohibit, with the requirement of specificity and a warrant before searches and seizures could take place. Now, these data mining programs and programs like the FISA Amendments Act of 2008 invert that presumption and allow massive warrantless data collection without any particularized suspicion whatsoever. If they had that particularized fact-based suspicion, the laws would be a lot less objectionable. But the fact is that they don't. And the reason that there's this conspiracy of silence in the Congress and among both of the presidential candidates today is that it's politically popular. It's very difficult to have the courage in this, what used to be the land of the free, home of the brave, to stand up and say, we're not going to make policy out of mere fear. We need to have a prudent risk management analysis that takes into account the real quantitative and qualitative harm, and then has laws that are consistent with our constitutional traditions to address that harm. And these laws are inverting that presumption and that approach.
Doesn't that concern you at all, David Isby? The Fourth Amendment, protecting against unreasonable search and seizure, clearly that's...
Very, very much so, but I don't think anyone who listens to the internet or how many channels of cable television believe there's a conspiracy of silence on really anything. Yes, it is and of course, to an extent, to what extent is this a legal issue and what extent is this a policy issue, to be determined not so much by litigation, but by election and eventually what the people want in elections. So that is also another thing. It is a very serious issue. There have been abuses. One can bet there will be abuses in the future. The question is how best to deal with them. And one of the things which there are many volumes on civil relations of the military, control of intelligence, both foreign and domestic, is something we only started to address in the 1970s, and we've not always been successful. Same with other democracies.
But you're quite happy for the National Counterterrorism Center to be having these vast data mining operations, and then we understand from the Washington Post last week, collating so-called disposition matrices, or a disposition matrix, which then decides who should be killed or apprehended without any due process. And that just seems perfectly...
No, whether I am happy or not, the question is whether it is done, and whether it is a good or bad thing is not the issue. The issue is, is there a constitutional authority for it? And whether it is a good thing or not is not what we're talking about here.
Interestingly, though,
and the problem is that, if I may, the basic legal minimum that David refers to is being ignored in this instance, the constitutional amendment of the Fourth Amendment. And the reason is that our politics have become utterly dysfunctional. And part of the reason is that we're going against basic principles like democracy, like transparency, like free speech, like accountability, the rights that provide the very infrastructure of our freedoms and success, prosperity, and defense as a nation. Now, we can't have a democracy if you are at risk of having your privacy infringed and your free speech chilled by ubiquitous warrantless surveillance. That's
Canadians
attacking the very
warrants.
core of our... Canadians have general warrants?
Yeah, come on, that's... I agree with the thing, but yet you're making an overbroad, like I said, an overbroad statement. If you like these sort of statements, I refer you to the internet, where there's thousands of people who say them, and there is not without truth. Their concern is there. But this is something where we have not, and no one has gone to jail, or unfortunately people have suffered, not all of them Americans, the people whose names get on the do not admit lists. There are many people named Paddy Murphy and Ahmed Rashid who share the same names as terrorists. There are many abuses, but that does not undercount. There is a constitutional grounding here, and if the whole political system is as dysfunctional as you say, Professor, what you're saying is the worst of it. Then we better head for the high ground, and this is only part of the symptoms of a much broader malignance.
Well, as we look at President Obama's wider record then, and we connect then these expansion of these powers along with items like the National Defense Authorization Act allowing for indefinite detention. I mean, how can we, I mean, if we take the broad view of President Obama's record, I mean, and you put all of these separate things together, it's pretty frightening there, isn't it, perhaps, Professor, arguably?
Absolutely. And I do think that the dysfunction, I haven't given up yet, but it does cause you to want to flee for the hills sometimes. But rather than do that, I think that it's incumbent upon American citizens to become educated, to delve beneath what's said in Congress. The House debate on this reauthorization of the Foreign Intelligence Amendments Act was completely misleading. A lot of Republican congressmen said that there was no prospect of any Americans being targeted when the national security officials have admitted that Americans have had their communications intercepted. And it's been done on a massive scale. So the problem is that our politics, our democracy is becoming corrupt. And part of the reason for that is the direct economic interest of the massive homeland industrial surveillance complex that's linked in turn to the corporate finance problem we have, with corporations controlling our politics increasingly. We need to get a hold of these. These are bigger challenges, and it is necessary for us to get a grasp on them and start addressing them if we're going to have any hope of reinvigorating and recapturing the core values that made this nation the great nation that it is.
Look, I'm a national security expert. I'm not a made-up or real conspiracy expert, so I really can't argue with you there. However, there is a real threat, that of terrorism. Here is a message. Here is a potential remedy. It does have, like everything else, the potential to be infringing, and we're going to have to work on that. And this is why you did end up, but like I said, when you have ended up with both parties in Congress, both administrations working on it, you do need something like this. Now, maybe, like they said, they're all in on it. Maybe all the people who work for Homeland Security and the border and the people who sell them software, maybe they're all in on it too. If you're right, I can't argue with you because I don't know. I haven't been invited to participate in the conspiracy.
It's interesting, though.
I'm not arguing, I just want to be clear, I'm not arguing this is a conspiracy. I'm saying that it is, in fact, the predictable dysfunction of interest that are allowed to perpetuate themselves without accountability, without checks and balances, without reason, because they're making decisions out of fear. And what we need is courageous leaders. Now with Senator Russ Feingold out of the Senate, you're relying on people like Senator Wyden of Oregon. But the courageous voices, the true leaders who want to stick to principle from either the left or right, are being dwarfed by the interests that require them, and essentially a corrupt system, to continue to be elected, to kowtow to the economic interests that are basically making it possible for them to keep their offices.
I didn't see, for example, the McCain Amendment some years ago, which ended, much of the procedures with dealing with foreign detainees. I don't see much kowtowing in Washington. And yes, and if this is dysfunctional, like I said, then this is not the worst part. Then there's a lot of dysfunction, and it's such an overwhelming issue, I really can't, if you bring up specifics and precedents, I'll argue with you, but otherwise...
But you don't think there's any danger of sleepwalking into a very dangerous, but potentially tyrannical national security state, basically?
And again, I think, as long as the press and the Congress and everyone else does their job, and both a two-party system, there are going to be problems, but I don't think we're going to sleepwalk into disaster. More likely to prevent, the years of preventing terrorist attacks, that's what is more likely if you keep to this.
Professor Pitts, do you think it's easier for a Democratic president to kind of push through these sorts of curtailments on civil liberties rather than a Republican president?
Actually, I think that most of what Obama has done, President Obama, has basically continued most of the Bush policies against terrorism. And I would agree that that's, with David, that that's happening. The reason is the electoral politics. It's very important for Democrats to stand up to terrorists and to be strong on national security, to counterbalance the stereotype fight the stereotype that they're weak on national security, even though, President Obama has killed Osama bin Laden and taken harsh measures and so forth. What we need is a more rational politics that puts the threat in perspective, that requires fact-based reasoning. And I don't know if David's living in the United States, but I think anyone living in the United States right now that says our politics are working isn't seeing the reality.
Professor Pitts, thank you very much. Chip Pitts, David Isby, thank you very much.
I can't fire the electorate, I'm sorry.
David Isby, thank you. That's all from the team in Washington, D.C. for now.